as it stands needs strengthening, even as we say that it requires significant reforms. The views of the Chief Justice and the Collegium are sacrosanct, and they ought not to be overridden by the government or even a subsequent Chief Justice or a reconstituted Collegium. So there is, in fact, in the recent past, where there have been resolutions, recommendations, which have been recalled by a reconstituted Collegium merely because a judge of the Collegium has retired. Right? But that practice is a departure from the primacy principle. Therefore, CJAR recommends that the Collegium not to have suo motu powers to recall or review its decisions. The power of reconsideration of a recommendation can only be at the instance of the government and on the basis of any fresh material that the government is able to place, not based on material that had already been placed. So this is what we call the first principle, the primacy principle. And the second principle is the immutability of reiterated recommendations. So these are principles that are there in the judges' cases where it is largely a re-invocation of those. But what does immutability really mean? The President's Secretariat is in effect duty bound to take steps for the issuance of the warrants in line with the Collegium recommendations without further reference to the government. This is something that we are proposing. The President's Secretariat should place the file before the President for the warrants to be issued. The government and the Collegium become functus officio once the reiterated recommendations go. The third principle that is also perhaps very relevant to what is happening of the recent developments in the case of Madras High Court recommendations, where the Collegium where the government has been able to split the recommendation, despite the recommendation unequivocally saying that a certain name shall be senior, the other appointments being made without that name being appointed. So this principle we call the indivisibility principle. This is the principle number 3. Each recommendation of the Collegium is indivisible. The government's actions to divide and split the recommendation of a Collegium is a violation of the principle of CJAR primacy. We said this principle 3 is very much derived from principle 1. And CJAR would also like to make an appeal to all the split appointees to not take oath or assume office if the recommendation had not been adhered fully. So the fourth principle or fourth norm is that's the suggestion that had come up. Several of the speakers in the first half of the day had also indicated that there has to be an independent search committee / secretariat. Right, there are two different terms used. We want to put both on the table here to assist the Collegium to firm up its recommendations. Right. And the committee is to be independent of both the government and the judiciary. Committee to solicit public feedback on the names within the zone of consideration. The Collegium already works on the framework of names in the zones of consideration. So all those in the zone of consideration, the search committee or the secretariat may be able to solicit feedback on. So that's principle number 4. Principle number 5 is transparency and impartiality. There has been significant, it has received significant attention in the first half of this discussions. Therefore, I quickly run through the points. So it has to be no gainsaying at all to say Collegium has the responsibility to be an exemplar in terms of transparency and governance norms. All discussions on suitability and eligible to be closely minuted and filed. All minutes except those that relate to the discussion as to suitability of candidates who were eventually not appointed, except those, everything else to be proactively disclosed. The discussions in respect of people who have already demitted office also to be proactively disclosed. And the discussions in respect of those persons considered and eventually not appointed may still be held, and such records to be destroyed or archived only upon such a candidate no longer being eligible or appointed. So that is to say that there is at least on the file, there is transparency even if there is no disclosure. That causes sufficient deterrence in unconstitutional or unsuitable appointments being made. So the last point relates to impartiality. This is something that Professor C. Rajkumar addressed in his speech as well. So no collegium shall consider or discuss appointment of any candidates who is a close relative of any member of the collegium, or in cases where any member is reasonably conflicted. Reasonably conflicted, what amounts to a reasonable conflict, I think the speakers in the panel before had indicated. So the sixth principle, the last principle, is the commitment to increase in diversity in representation, social, regional, and gender. So this also came out of the first two sessions that we had. So some of the recent criticisms of the judicial appointments being not being diverse enough, I think CJAR supports and endorses that criticism. Collegium to proactively commit itself to increasing diversity. There are factors such as regional representation, seniority, etc., already mentioned under the judges' cases. We say that other factors, including all the factors mentioned in 15, say Article 15, as well as those factors such as disability be considered. And the search committee to assist the collegium must prioritize this requirement. So these six principles, CJAR sums up as those that emerged out of the discussion earlier. If there are any further principles that we want to add in the subsequent discussion, that we may try and discuss those and see if we can incorporate those in the resolution. Thank you very much.
Thank you, Prasanna. I now invite the panel to please come up on stage. First of all, I'd like to invite Justice Indira Banerjee. She's a former judge of the Supreme Court of India, serving for a period from 2018 to 2022. Her lordship was the 8th woman to be a judge in the Supreme Court, and she had previously served as a Chief Justice of the Madras High Court. She was in the Supreme Court on several important constitution bench decisions dealing with issues from bail, drugs to narcotics offences. Welcome, Justice Banerjee. I'd like to invite Justice Anjana Prakash. She's a former judge of the Patna High Court and a senior advocate in the Supreme Court. She's been speaking out very strongly on various issues affecting the Republic today. A very warm welcome to Justice Prakash. I'd like to invite Mr. Sriram Panchu, who's a senior advocate at the Madras High Court. He has many decades of experience in the legal profession and is internationally recognized for his expertise in mediation and arbitration. Welcome. I'd like to invite Anjali Bharadwaj, who's a founding member of Satark Nagrik Sanghathan, is a co-convener of the National Campaign for People's Right to Information and is also a member of CJAR, and Mr. Prashant Bhushan, who's the convener of CJAR and well known for his work in public interest litigation. So, having heard many speakers in the earlier two sessions, this panel has the work of actually laying out, in some senses, the way ahead. What do we see as the key principles and framework for judicial appointments? And I'll just take a minute to perhaps just point out a few facets that I hope the speakers will be covering. The first, of course, being transparency. We've heard a lot of it in the previous session as well. Diversity. I think the issue of assessments came up, that how do you assess those who are being appointed? So perhaps something around that the speakers would like to reflect on. On the issue of accountability, that once appointed, then what happens? What is the framework for accountability around that? And also perhaps a framework of, does something like a full-time secretariat or full-time commission? So how do the speakers view each of these issues? And without taking up any more time, I'd first like to invite Justice Indira Banerjee to please share her comments.
Distinguished panelists on the dais, ladies and gentlemen, a very good afternoon to you all. I'm happy to be here to share my views on a topic which has assumed extreme importance today. In our country, under our constitution, we have the Union Judiciary under Chapter 6 of Part 5 of the Constitution, which is the Supreme Court. Then we have the High Courts under Part 6 of Chapter 5, a High Court for each state. Sometimes we have one High Court for two states, one High Court for a state and a union territory, or a High Court for a union territory for that matter. Then, of course, we have the subordinate courts, which are covered by Chapter 6 of Part 4. The appointment of the district judges under Article 233 and other judges under Article 234. If we go upwards from the lowest level, then so far as appointment of other judges are made, there the governor has to act in accordance with the rules, in accordance with, after consultation with the Public Service Commission and after consultation with the High Court. Since these appointments are made on the basis of a competitive examination, followed by an interview conducted by the Public Service Commission, in which there are representatives from the judiciary, from the Public Service Commission, and from the Law Secretariat of the state as well, there is not much criticism with regard to these appointments. There is a certain amount of fairness. Under Article 233, the governor, in consultation with the High Court exercising jurisdiction, is empowered to appoint district judges. The minimum qualification for direct recruitment is 7 years practice as an advocate. But even these appointments are made on the basis of a competitive examination followed by an interview. Though there are some appointments which may not be that good, because, every system has its pitfalls. There is no complaint really with regard to the system of appointing district judges either. Now comes the appointments to the High Courts and to the Supreme Court, which is important and which requires a lot of thought. It requires discussions. And under the present system, we are bound by the Constitution. I can only say that the selection is not easy. It requires care and attention. Talking about the Constitution, the father of the Constitution, B.R. Ambedkar, had said, A good constitution may not be a good constitution if the persons who are responsible for its operation are not competent. A bad constitution may become a good constitution if the persons who are administering the constitution are good and upright. The same principle, in my view, applies to judicial appointments. There should be fairness. The persons, the selectors, should be persons of integrity, absolutely impartial, and what should be of paramount interest is to have persons in the higher judiciary, in the constitutional courts, the Supreme Court and the High Court, persons who are absolutely independent, persons who are impartial, persons of unquestionable integrity, hardworking persons, persons who read the law, who know the erudite. We should have able, erudite judges. Now, the entire object is to have able judges of integrity. There can be no dispute with this proposition. Now the question is, how do we go about it? There have been discussions with regard to the collegium system, and whether you agree that there should be a collegium or there should not be a collegium, the fact remains that that is judicially established. So we are bound by the collegium system. There may be criticism of the judgment whereby the 99th Amendment Act of the Constitution was struck down and the provision with regard to appointment on the recommendations of the NJC was struck down. Now, whether you agree with it or not, the fact remains that there is a judicial pronouncement of the Supreme Court which is binding on all. So what do we do within the system? We are talking about transparency. We are talking about absolute honesty on the part of those who are there. I make it very absolutely clear that I'm not attacking any particular collegium, any particular judge, and I'm not referring to any particular selection or any particular rejection. But I am just I am just giving some examples. Now, before I forget, when we go on to the recommendations which were made, I agree with all of them, except for one. If the appointment to a constitutional court is something which is very important. Now, if a collegium on the basis of materials on record has doubts with regard to the correctness of a decision taken, I do not see any reason why the recommendation cannot be reconsidered, provided the reasons are honest, the reasons are genuine, and there are grounds for it. I will give you a very small example. I was in the collegium hardly for 1 month, and that too, I may say, by default. I was appointed under the collegium system. So in that sense, I'm a beneficiary of the collegium system. My appointment may have been delayed. Personally, I was very happy because I always say that my tenure in Madras High Court as its Chief Justice was the best part of my judicial career. So personally, I may have been very happy. But if you look at Calcutta High Court, between 2013 to 2018, there was no appointment from Calcutta High Court. I got appointed on 7th August 2018. So you talk about regional representation. So here was a chartered high court, one of the oldest high courts in the country, which did not have any representation at all in the Supreme Court from May 2017, when Justice P.C. Ghosh retired, till 7th August, when I was appointed. Now, I was in the collegium for less than a month by default. Suppose a decision had been taken, not forwarded to the government, but some genuine reasons were discovered. Would the newly constituted collegium become completely powerless when the appointment is such an important appointment? Once a judge is there, what is the procedure for removal? To deal with that, in 1999, the full court of the Supreme Court had evolved a procedure of internal inquiry, which also does not get much publicity. The proceedings are carried out secretly. But be that as it may, at least in one case, where I had recommended the removal of a judge as chairperson of the inquiry committee, nothing happened, except that the judge was not given business. Now, if a judge is simply not given business, what happens? Nothing. It's the exchequer who loses out because no work is done. So that recommendation that the decision of a collegium is sacrosanct. Today, all decisions since 95-96 have been on the basis of the recommendations of a collegium. Some have been cleared by the government, some have not been cleared by the government. That is a different issue altogether. But why are we talking about all this? Why are we talking about transparency today when all the appointments are actually made by the collegium? We must know what is the procedure for selection. What is the discussion that is taking place? And if a candidate who has not been considered wants to know the reason why, communication to that candidate. We have to balance the need for an independent, strong, impartial judiciary with the right to equality of possible aspirants. Because an appointment to the higher judiciary involves expenditure on the public exchequer in the form of the salary and the perquisites and the various other privileges which the judges of these constitutional courts enjoy. not only during their service, there are many benefits which continue till after retirement. Now, under the Constitution itself, there is a criteria for appointment laid down. That is the minimum eligibility. That has to be streamlined. Now, under Article 123, Sub-Article 3, the minimum eligibility for appointment to the Supreme Court is that one should have been a judge of the High Court for only 5 years. That makes every judge of the High Court, except perhaps a few service judges who retired within 2 to 3 years of their appointment. Almost all judges who who get appointed to the High Court are eligible to be appointed to the Supreme Court. The other thing is, a person who has been an advocate of High Court or 2 or more High Courts in succession for 10 years can be straight away appointed to the Supreme Court. And the third category is distinguished jurist in the opinion of the President. A jurist is an expert in law, but the expression used is distinguished jurist. So what is going to be the criteria for distinguished jurist has to be formulated and laid down in black and white. I always say that in every case, exceptions may be permissible. But when exceptions are made, there should be good reasons given as to why that exception is being made. Again, I will quote with an example. When I was appointed as a judge, when my name was recommended, I was 43. When I was appointed, I was 44 and a few months. I had not completed 45. A few years later, around the time when Justice K.G. Balakrishnan became the Chief Justice of India, he made it an unwritten rule that the minimum age for appointment would be, would be for 45 years. But later on also, persons less than 45 years of age have been appointed. Of course, I don't think it makes a world of difference whether a person is 44 or 46. I always believe in the principle of catch them young. If a person is doing well, if a person is competent, catch him young before he starts earning so much that he will say, I can't manage with the salary and the perquisites which the judge gets. So it is fine to appoint young judges. We have had young judges who have been very good. Our present Chief Justice of India was appointed when he was only 40 or 41 years of age. And I don't think those who have been appointed at 55 are necessarily better than him. Experience may be important, but not a rigid divide. The second factor which is taken into consideration for appointment as a High Court judge is income. There is a basic income. Now, this income criteria cannot be a uniform one for the entire country, because a person earning in Himachal Pradesh or in Uttarakhand and a person earning in Bombay or Calcutta, it would be like comparing oranges and apples. If you apply the same income criteria for all of them. So what are you going to look at? I will start with the High Court, because most of the appointments in the Supreme Court are from amongst High Court judges. But there is something common. People were talking about a secretariat or a separate department, a permanent one. I endorse that fully. You have to have a bank, a candidate bank, if I may use the expression. In that candidate bank, you should have names. Since that is a bank, I'm not going into the question of under whose control that bank is. It may be a secretariat of the collegium. It should be a secretariat of the collegium. But there should be a permanent register maintained of prospective candidates. Now, how do you do this selection? Anybody, but it should be a recommendation by any judge of a constitutional court for the purpose of consideration, for the purpose of inclusion of the name in the bank, subject to fulfillment of the other criteria. The recommendation of senior advocates, the top lawyers from the bar, recommendations also from the bar associations. But here there is a caveat. One should ensure that the recommendations are genuine and not a ploy to appease the bar with a view to secure votes in elections. Please excuse my saying so. I am always very frank, whether it is about the judiciary, about the lawyers, or anybody else. So we have to guard against this aspect. Therefore, I do not say that you do not accept the recommendations which come from the associations. They should be supported by the reasons for the recommendation, which should have certain particulars of the cases handled. Similarly, there may be others. Dr. Mohan Gopal, who has headed the National Judicial Academy for a number of years, he may be in a position to suggest from out of the resource persons, from out of the participants, from out of his interactions. Consider them. It is only you're preparing a bank. From that bank, you select the best. Now, what are the factors one is to look into? I think the academic background of a person is important. You can't ignore it altogether. So the academic background, the practice, court appearances, decisions reported and unreported, drafting skills, proficiency over the language. As of now, the language of the High Courts and of the Supreme Court is English. By proficiency over language, I don't talk of writing literature the way some of our judges in the past have written their judgments. I speak of correct, intelligible language which will be understood by all. And I think the drafting skill is very important. You assess the drafting skills in the high courts which have an original site, usually the name of the draftsman is mentioned in the plaint. Even otherwise, you can hold discussions with senior counsel who may have had the occasion to go through the pleadings. Now, coming to the appointment to the Supreme Court. Usually, since I have been in the collegium for a short while, and though I was the Chief Justice of Madras High Court for a year and a half, for the first few months, there was no occasion for me to hold a collegium or to decide, because Justice S.K. Kaul, my predecessor in office, very efficient as he is, he had recommended names in anticipation, which again should be done. The day a judge is appointed, the date of retirement of that judge is known. So I see no reason why the process of consideration or the process of consultation should commence after the judge has retired or just prior to his retirement. This can be done well in advance for a proper selection. Now, talking about my Madras experience, these things also happen. First few months, I was not in a position to hold a collegium. Then we decided on a name which had been actually recommended by my predecessor in office, but had not been cleared on the ground of want of experience. The ethics of the gentleman, I would say, was remarkable in today's world. Since his father was a judge, he decided to take up teaching. He was a professor of law. He came back. Now, I decided to reconsider his name because by that time he also had sufficient years as a lawyer. My second judge put a condition on me, and that too through my personal secretary, through my PPS. He said, on the first day, he said he needed to consider. So I said, certainly. Every judge has to consider. A few days later, I was given a name in a slip of paper, the name of a lawyer I had not had occasion to assess. And I was told that, tell ma'am, I'll agree to her name if she proposes to this name. I said, sorry, I have no personal interest in any appointment. I was doing what was good for the institution, and I'm not going to compromise with the good of the institution. I'm glad the candidate is a judge of the Madras High Court today. I did not have the privilege of recommending his name under these circumstances, but I had occasion to clear his name as a consultee judge when I was in the Supreme Court. Justice Ruma Pal, who had been a member of the collegium for a while, had shortly after her retirement written an article which I had read in the papers, where she had said that what goes on in the collegium is often you scratch my back and I scratch yours. This must have been set by her in 2006. She had retired on and from 3rd June 2006, and this article came out shortly afterwards. Now, this is most unfortunate. We have to remember what is the oath of office which we take. It is as per the 3rd schedule. We take a vow of allegiance to the Constitution of India. We promise to uphold the sovereignty and integrity of India and to discharge our duties of office to the best of our ability, knowledge, and judgment, without fear, favor, affection, or ill will. This does not say judicial functions. It says discharge the duties of my office. So when a judge discharges duties, whether the duties are judicial duties or administrative duties, this oath has to be kept in mind. It has to be without fear or favor. Sorry, 2 minutes, okay. It may become 3. It's very difficult to. Now, it is quite possible that at a given point of time, you may have 5 names. And the collegium thinks that they are all capable, but recommends the name only of 4 candidates because there are 4 vacancies there, or only 4 vacancies are contemplated. It should not happen that with the change of collegium or change of Chief Justice, you forget about that candidate altogether. So this uniformity and consistency should be there. A lot of it is, of course, corridor gossip. We don't exactly know what is happening inside the collegium because the proceedings in the collegium are not publicized. But you should also not give your ears to gossip, because just the other day, one of the judges appointed to the Supreme Court was recommended 2 days after my retirement. And there were a lot of collegium meetings held while I was still there. I don't want to discuss what happened during the collegium meetings because I am also bound to maintain the secrecy until the system is changed. Very recently, a friend from the bar came and told me, yes, we heard that the name could not be recommended because you told the collegium that the name should be recommended after your retirement because there is going to be a supersession and you are close to both of them. I looked at him and I said, what am I to take this as? A compliment that I should never have been on the bench of the Supreme Court? Is that the level of my personality, my courage of conviction? Was I expected to decide as per my personal relationships with people sitting there, or the competence of the candidate? So it was certainly not correct that I made any request of this kind at all. Anything more about the collegium, where differences arose, with whom differences arose, with regard to whom differences arose, I will not like to talk about, There were 4 or 5 collegium meetings, which no final decision was taken. The final decision was taken 2 days after my retirement, after Justice Joseph came into the collegium. Now, Justice Joseph, being the conscientious kind that he is, I'm sure, he had been making a study on his own of the candidates. But very often, when it is the Chief Justice who decides, it's the Chief Justice who makes the recommendation. The names are disclosed to other collegium members, and the collegium members consult, discuss, and then there's a vote. There is a third thing, last I'm concluding. I won't take any more time. We talk about regional representation. We talk about social diversity. But here again, we do not follow a very uniform policy. Of course, variations have to be made, as I said. Now, if there is no suitable candidate from a particular state, what do? You can't appoint an incompetent person. But then there should be a reason recorded somewhere as to why you are unable to consider any candidate from those states. Secondly, there should be exceptions to the principle of regional representation. Actually, I should not be taking names, but we talk about gender imbalance. I was very happy when 3 judges were sworn in on the same day. But then after my retirement, there's only 3. So many names were recommended, but there was no woman recommended. Why not? Possibly because of this regional representation policy. I see no reason why a second woman cannot be taken from the same High Court. If that woman is otherwise competent, she may have handled very high-profile cases. She may have expertise in a particular branch of law on which we need to give attention, because cases with regard to life and liberty are pending for years, so we may need lawyers who may be proficient in criminal law. We may need lawyers proficient in a certain area of law. But what happens is that we have one lady, we have 3 others, so there are 4 from one High Court. Why can't we have the 5th one? And last, the collegiums should refrain from hearsay. I have heard, many of my panelists may know about this, that my former colleague of Delhi High Court, his pet name was Boozer. But he was a teetotaler, unfortunately, or fortunately, whatever it is. His name was cleared by the collegium. The police report was that he was a drunkard. Many, many years later, he was elevated to the bench, but by that time, he had a very short tenure there. So if there are whispers, if there are murmurs, it may be a good idea for the collegium to invite the judge concerned or the prospective judge in the case of the High Court for a cup of tea and to get a clarification and then make some further inquiry before taking a final decision. Thank you very much. There is a lot more to say, but then I can't eat up everyone else's time. Thank you.
Thank you so much, Justice Banerjee, and I apologize for stopping you. I think the insights that we are getting into what actually happens in the collegium has been the most interesting part. Perhaps CJAR can evolve alternative minutes of the collegium, hearing what all actually transpires. I'd now like to invite Mr. Sriram Panchu to please come and speak to us.
Justice Banerjee, fellow panelists, ladies and gentlemen. This is the topic of the season. Judicial appointments in the collegium. And does it strike any of us as strange that after the NJSC judgment, we didn't have any controversies about this? I was thinking about it and a phrase came to my mind. And the phrase is the silence of conveniences. Because for the last so many years, there's been no problem whatsoever. And I think that tells a tale. It is the story of the Qureshis and the Giants Patel which tell a tale. And those are the acid tests. And if we fail these tests, we can have any number of consultations, methodologies, systems, but ultimately they must pass certain acid tests. I mean, nobody doubts that this was a constitutional coup, all right? This second judge's case. But just imagine if it hadn't happened, what would be the position today? Because you have a law minister who treats the court like an opposition party. So today you would have consultation in the following form. He would have sent a letter to the collegium in a sealed cover. And he would have said, consider only these names. It's not you, it's happening. And that would be consultation. So much as, the second judges, I think, departed extensively from the Constitution, I think necessity found a law. My only regret is that they didn't work it better. Because they've had 25 odd years to work a system in. And if they had worked it well, it would have been enshrined. And although we had many good appointments, we had several questionable ones. And I think we've had a very sad run of several Chief Justices on whom it is difficult to lay pride on. And let us remember that every indifferent Chief Justice produces many indifferent picks as his nominees for judges. But we are now in the now. One thing is clear, nobody wants it to go back to government. Okay, I don't think even government thinks it's a remote possibility. We are safer with the court, but that is said with caveats. And I think we need to make that abundantly clear to the court. Look, this is not unstinted faith and confidence in you.
We are safer with you in contrast to government. But there are caveats. No one is happy with the way you worked. You have an opacity. You have a limited circle in your view from you to a point, and you have any number of cases of favoritism. So maybe the answer is a search and evaluation system to take it out of the collegium at that stage. Because these are busy judges, whether in the High Court or the Supreme Court. They are busy judges. They do not even have the time now to interview a candidate. I mean, would you or appoint, or I appoint even, somebody to work in our office to do clerical work without an appointment, without interviewing? You wouldn't. So how do you appoint judges without interviewing them? Judges of constitutional courts? So let's have a search and evaluation system. But search wider, not just the people who appear in your courts and who are recommended by the Bar Association chairman. Search wider. Look at district court lawyers. Look at lawyers who represent NGOs. Look at academics. Search beyond that upper caste and middle class formulation. Okay, search wider and evaluate better. Take your time to evaluate. Interview people. Look at their records. And suspect the IB. Suspect the IB. Okay? There is a role for retired judges in this search and evaluation. Not exclusivity, but there is a role for them. And I think it's a far better role than becoming a governor of a state. But at the end of it all, I think we keep hearing transparency. And I think that's the key really, open it out. Let us know what people are saying, who's recommended, who, on what basis. Let us know. If you have the guts to recommend somebody who's inferior, well, put it out over there, and then we'll see how many recommendations come. Who's recommending, who's backing, who's saying yes. From that transparency, you will get accountability. Because it is nothing like the fear of exposure. So put in transparency, it doesn't matter. Tell candidates, look, you may have to go through a certain amount of pain if you want to be considered as a judge, but go through with it. And tell us at stage one, tell us at the end, which names are going to the collegium. In other words, trust the process, not the person. I know that in a different context, Dr. Ambedkar has said we may have any kind of a constitution we like, it's the people who work it that matter, and that is true. But it is also true that persons let us down. It is also true that the best of persons can let us down when we expect it the least because we think the best of them. Because imperfection, I suppose, is a part of our very being. So let us learn to value the processes. And I think if the processes are good, even when the best falter, the process will steady them. There is another thing I want to, just 2 more points and I'm done. I want to talk about something called institutional deference. And this is a culture. It is not, written in a statute. It is a culture. And that is a culture which is now found wanting. The law minister does not show institutional deference to the court by splitting up recommendations, by notifying Victoria Gowdy's judgeship on the day after the Supreme Court takes up a petition. The judges of the High Court did not show an institutional deference to the Supreme Court by proceeding to hear the case at 10:35 when the petition to challenge her judgeship was coming up that morning before the Supreme Court. And I'm sorry that the Supreme Court did not come down heavily on them. Everybody failed the Supreme Court in this particular troublesome candidate's case. The collegium of the High Court, what happened to the consulting judges here? Why was it that when this matter is brought to Justice Chandrachud's notice, the Chief Justice says, I didn't know about this? So this is an institutional deference which was due but not paid. You know, more judgments will not get it. But you have to demand it, you have to enforce it. The more you let the law minister slide on delay and indecision and sending back multiple times and not appointing and splitting up, etc., he will do it. But you have to be firm. That is the only way you will, by solid performance, will you secure this institutional deference. My last point. If we are to have a collegium, who should be on it? In a piece I authored some time back, I said, if there is a collegium of 5, let there be a majority for the judges, 3. Let there be a place for the law minister with these reasons. 1, no veto. 2, primacy for the judges. 3, finality at the table. He comes to the table, says what he wants, but he's bound by the decision taken at that table. On that condition, he should be considered for a place in the collegium. It's a piece I wrote as an act of tossing an idea into the public discourse. I must say I have received, views in support of this, but also very, very threatened, very scared responses. And that tells me that the law minister, types of law ministers have changed. What about the 5th place? This again is, I think, we need to consider one stakeholder who is deeply affected by every appointment but doesn't have a place on the table. And I think that is the bar. Judges who appoint will leave soon. It is the bar which benefits from a good judge and suffers from a bad one. And it is the bar from which you hold no secrets. You may have judges on the appointing panel who do not know much about you or who know you too well, but you will not hold secrets on the bar. There may well be a room for a bar nominee, and I'm cognizant of the fact that it's not safe, it's not so easy to find an absolutely safe bar nominee. I'm cognizant of that. But I think we need to see, while giving the judges primacy and majority, I think exclusivity is another thing altogether. Thank you very much.
Thank you for that, Mr. Panchu. And in a very short time, I think you unpacked several aspects of the appointment process. And I think the key, really what you said was that we need to trust the process and not individual persons. I now invite Justice Anjana Prakash.
Good afternoon, everyone. Dear panelists, the remaining persons in the auditorium. It was often said that never take the risk of inviting a retired person, much less a judge, because that judge does not have any work to do, so will just come and lecture and say things which he had never said in his judgment. Anyway, thankfully, I will spare all of you of that. Actually, what I think it is unfortunate that we are debating this issue, whether or not the collegial system is the best system, when the executive is attacking us. It should have come, on account of some soul searching. And this I say because while we are here defending the collegium system as best as we can, one lady judge is being appointed, a lady who has a limited past, she's being appointed by the collegium's recommendation. So what do you say? Actually, unfortunately, what has happened is that all that we have reduced our debate to is as to who should have primacy over appointment of judges. Whereas fact of the matter is that we should have thought as to who has to have the responsibility of picking the best judges. We're not talking about talent anywhere. Unfortunately, the judges system also does not, the collegium system does not defend itself, saying that it is the only competent body which can pick the best persons. If they had said that, there would be some kind of a responsibility attached to it, because then you would attach yourself, to the merit of that candidate and nothing less. So that was important, and that should be the debate, according to me. The quality of our processing, the quality of our recommendations, that should be the debate, not a debate on who should have the primacy over appointment of judges. There is one thing that I want to say is, I'm really pushing for it, is that as we know the collegium system, the High Court sits along with the two senior most judges and picks the judges to be appointed, etc., and recommends it to the Supreme Court collegium. According to me, the High Court should have the last word on the future appointees or the probable appointees, for the simple reason that it is a constitutional court, and it has to take responsibility again of appointing the best judges in its own court. What happens is that, as Justice Lalit pointed out, that's one way of looking at it, is that every time the names are sent, a consulting judge of the same High Court is also consulted in addition to the collegium of the Supreme Court. Now what happens is that Justice Gupta pointed out that all the time the High Court judges keep looking up at the Supreme Court and trying to please the consulting judge or the collegium system or the collegium judges, for the simple reason that they are also likely to be elevated to the Supreme Court. So they don't want to miss their chance. In order to not to forego their own prospects, they are ready to sacrifice the judiciary as an institution. Now, this is very, very objectionable. And according to me, this could be, the plug could have been, actually it could have been plugged, this problem, if we have this, or we have the increase of judges' retirement age, as Justice Gupta pointed out. Only then, you can feel as though you're equal to the Supreme Court, and, you don't want to please the judges as in your own favor. The third thing that, of course, everybody has been talking about is diversity. Now, there are two types of diversity that I especially wish to emphasize. And one is that, unfortunately, as we see, in the Supreme Court, you don't have most of the judges are not exposed to criminal law at all. Now, that branch of law is extremely important, which we tend to ignore. Because it is in criminal law that you learn what human rights is all about, what the socio-economic status of a populace is. So everything, the criminal law revolves around these issues, which is very important. Now, the Chief Justice, more often than not, he sits in a bench which does not hear criminal appeals or does not hear criminal matters. So he does not know any of the judges who are practicing on the criminal side firsthand. So this is one reason why criminal lawyers are kept out of the purview of selection range, And this, I think, is very, very important. We need to plug this. The second thing is, people, when the judge's case was, when the collegium system was adopted, they laid down one criteria for future judges, and that was on the economic strata. Now, anybody who's actually practiced knows that, caste is directly linked with economic status. And if a person is judged on the economic status, the caste A caste person, a person belonging to a certain caste will automatically be edged out. He's disadvantaged. So, and then to think, that you have a feeling that you will pick only a person with a certain financial ability or his practice, you judge that person, of course, that's very tangible. The way you judge the success of a lawyer is by his income tax. So that's a very tangible way of looking at it. But there must be something more holistic than that. And that I would think would come more, from the understanding of the person as to his views, etc. So unless you pick lawyers from diverse backgrounds, you will never get, a good pick. And it is very, very humiliating when somebody thinks, that a poor person will not be honest. The whole, the criteria, why you have this financial, that you must have an income tax returns of this much value, because, the person who's earning well enough will not be tempted to monetary, corruption. Now, this is absurd. How, and it's very patronizing as well. How is a poor person presumed or assumed to be dishonest, and that every time that is given a plate full of food, he'll grab at it? How do you think, these kind of biases, etc., need to go in from the selection process? Only then, I guess, there can be some improvement. And we actually need to do soul searching. I don't agree with the search committees that, the principle of search committee, because the more search committees that you have, the more corruption is going to breed, So I'm against this. Let the High Court Collegium take the responsibility of picking the best persons, and they alone are competent to do so. Let them take the responsibility. Thank you.
Thank you very much, Justice Prakash. And I think in terms of diversity, you opened yet another axis of experience of criminal law. And I think that's something that perhaps needs to be focused on, even when we are looking at not just gender, caste, geographical representation, but also what is the background of the practice of law. So thank you for that. I now invite Anjali Bharadwaj to speak.
Thank you very much. And I've been asked to focus on the principles and framework for judicial appointments, and specifically on transparency. And I think a very rich discussion took place in the previous session, from which we can draw many things, which has made my task very simple. I want to start by saying that as citizens, it's amply clear to all of us that today the judiciary is the final bastion for protecting our constitutional rights and for protecting us against executive excesses and arbitrary use of power. And I think that it is from here that as citizens, we want to look at what the process of judicial appointments should be like. Because what we are seeing is that at a time when all institutions, and I'm saying this with some responsibility, almost all institutions that we look at, which are responsible for holding the executive to account, are being undermined, their autonomy is being compromised, it is very important that the judiciary remain independent. And when we talk about justice and we say that it's not enough that justice is done, it should also seem to be done. I think when we say that the process of judicial appointments is fair, it should also be seen by citizens to be fair. And the only way in a democracy to be accountable is to be accountable to the people, which can only happen when there is public scrutiny and people are allowed to look at the process as it unfolds. Now, I think that we need a situation where we have to ensure that people are where we have to ensure that there is no executive influence, there is no nepotism, we heard that term time and again, no arbitrariness in the process of appointment, which adversely impacts diversity and representation also. So all of these things need to be seen by people as the process of appointment happens. And to draw principles and frameworks, I think it might be easiest to just look at some of the court's own rulings. And these are rulings which the court has given in terms of appointments to high public offices where there are institutions involved which are responsible for working independently and holding the executive to account. So the first case in this, which I want to highlight, is the case where the Supreme Court was hearing matters related to the appointment of the Central Vigilance Commission. And here the court held that since it's entrusted with the task of looking into cases of corruption, including against senior government functionaries, the decision to recommend has to be an informed decision. And the empanelment shall be carried out on the basis of a rational criteria, which is to be reflected by recording of reasons and on noting akin to reasons by the empaneling authority. In the case of information commissioners, the appointment of those commissioners, the court again noted that information commissioners have to be independent because finally they are responsible for making sure that they can direct governments to give information they might want to not give because it might be inconvenient for them to share. It might expose wrongdoing. It might expose human rights excesses, corruption. And therefore, the court went on to give a very, very landmark judgment in which the court said at least 5 things. It said that the names of applicants who apply and through an open advertisement process have to be put in the public domain. The court held that the names of the members of the search committee and the selection committee have to be in the public domain. The agenda for the search committee has to be in the public domain. The minutes of the search committee and the selection committee have to be in the public domain. And it also went on to say that while shortlisting the candidates, the shortlisting criteria has to be objective and rational and has to be put in the public domain. Now, when we hear about appointments and the process in the judiciary, I don't see why when for high public offices like the CVC or the CIC, these are the principles that need to be taken into account to ensure public trust and faith in the process. Why in the case of judicial appointments, and we're talking even about the higher judiciary, anything less than this should be acceptable. And yet we have seen time and again that the plea is taken that this kind of information should not be put in the public domain. There are several reasons for it, which also I will refer to. Now, as far as the framework for ensuring transparency is concerned, I think the prevailing framework for information disclosure in the country is the Right to Information Act. And that itself came as a result of a slew of progressive judgments by the Supreme Court. And what we are seeing is, unfortunately, that we don't see enough information being provided when people are asking for information under the Right to Information Act, including on judicial appointments by the judiciary. Now, of course, we've heard, and I'm going to repeat this, that when the law minister of a government which brings in electoral bonds to make the election funding process more opaque, a government which goes on to say that the PM Cares Fund does not need to be transparent, a government which says that the educational qualifications of its senior ministers don't need to be made public, I think when the law minister makes comments on the opacity in the collegium process, it does smack of hypocrisy. But as citizens who hold the judiciary in the highest regard and have great hopes from the judiciary, we do expect the judiciary to hold itself to those high standards that it itself espouses. And for example, in the case where Justice Gogoi's, the collegium did recommend certain names, but the decisions were then reconsidered in a subsequent collegium meeting after the collegium was reconstituted, and the decision was sought. The court actually, the grounds that the court took to deny information were very alarming. One thing that the court said was the decisions were perhaps verbal, they were not in writing. Now that is extremely concerning, because what that means is that if there is a challenge, a judicial challenge to those decisions, the court itself will have no way to examine and satisfy itself as to what happened. This is the ultimate violation of right to information of people, but also making sure then that the historical records of an institution as important as the Supreme Court Collegium are not kept. The other ground that was taken was that certain interim decisions might have been taken, but final decisions were not taken. Now, under the RTI law, it's very clear that any record that is maintained has to be shared unless it is exempt under Section 8 or 9 of the RTI law. Now, saying that it is an interim decision of the Collegium does not therefore preclude it from disclosure under the RTI law. So I think the judiciary, perhaps also flowing from today's discussion, needs to resist the temptation of carving out a special niche for itself when it comes to issues of transparency. And in the absence of objective information being put out in the public domain, unfortunately, it opens the doors for the governments of the day to make claims and propagate quote-unquote facts which suit the government. So I think it's very, very important that for there to be integrity, for there to be credibility, the judiciary must open itself to greater scrutiny, especially in the process of appointments. So there is clearly a need for radical rethink on transparency in the judicial appointment process. We've heard several suggestions today. There have been some who have spoken in favor of a search committee, some who feel that a search committee might not be necessary. A secretariat might be useful. Sorry. Thank you. So we've heard several discussions today about the process, whether there should be a search committee, whether a secretariat should assist the collegium. I think one thing that many of us have learned through experience is that there is really no perfect system or selection committee. In fact, many of us will remember that when the Lokpal law was passed, there was great jubilation. It was felt that the search committee and the selection committee was finally as close to perfect and balanced as it could have been. And yet we see today how the current dispensation has completely destroyed and subverted the process of the selection committee. So I think the only thing that opens things up for public accountability is transparency, and it must permeate every step of the process. Open advertisements and self-nomination. I think we talked about diversity and we talked about a boys' club. I'm not saying it, but I'm quoting the previous speakers. The only way to bring in greater representation, perhaps more diversity, and to make sure that the process is not arbitrary is if we have a process of self-nomination. And who are the names that are being considered has to be put in the public domain. The judiciary has to recognize that it's not the only place where names are being considered, some are being accepted and some are being rejected. So it has to open itself to that scrutiny. The names of search committee, the secretariat, whoever, whatever we decide, that has to be in the public domain. The rational and objective criteria for shortlisting have to be evolved if they are not already there, and certainly have to be put in the public domain. I think there was discussion about various ways in which evaluation can be done of judgments. But what are the parameters on the basis of which evaluation is also being done must be disclosed. The minutes and decisions that are taken by the search committee or the secretariat, and finally the The shortlisting of names has to be in the public domain, and the minutes of the collegium and the decisions taken of the collegium certainly have to be in the public domain. If there are certain things that are sensitive, certainly they can be redacted. Even under the Right to Information Act, there is Section 10 which talks about severability and redaction. And of course, like we heard today, the government's actions and inactions, there has to be complete transparency so that we as citizens know what is happening and at what stage things are getting stuck. So when Justice Gupta today gave us some of those statistics, which were really shocking, he said that they've not been verified, but if any of it is true, I think we have a right to know that if the government sits on files and takes its time, and there are certain communities or minorities where more time is taken deliberately, then it's important that people know how much time is being taken. If segregation is done, what is the reason for segregation? What are the reasons for not agreeing despite repeated or reiterations? And finally, I think that the issue time and again has been that transparency must not mean that independence of the judiciary is compromised in any way. And I think in 2020, the Supreme Court itself answered that and said that independence in a given case may well demand openness and transparency by furnishing information. Reference to the principle of judicial independence is not to undermine and avoid accountability, which is an aspect we perceive and believe has to be taken into account while examining the public interest in favor of disclosure of information. So thank you very much, and we hope that this framework and some of the principles of transparency are debated and they're adopted by the judiciary for judicial appointments.
Thank you for that, Anjali. I now invite Prashant to please come and speak to us. And after that, we will be presenting a resolution which we hope will actually be adopted by all the participants at the seminar today.
So we have heard since the morning the various problems with the present system of appointments. We've heard how the government is interfering with the recommendations of the collegium. We have also heard about how even the collegium has failed in different ways, in firstly making recommendations of people like Victoria Gauri, not following through with its recommendations for appointment of Justice Akhil Qureshi or Jayant Patel, etc., transferring Justice Tahil Rahmani, etc. So we have seen that there is nepotism also in the selections by the collegium. And therefore, the fact is that though the collegium system is better than the government making the selections or the government directly interfering with selections, because the collegium at least leads to slightly more independent judges being appointed, but it is far from perfect. And therefore, we do need substantial improvements. Improvements can be made, as have been suggested, to the collegium system as well. But if we have to think of the best possible system for making judicial appointments, we have to keep in mind the following principles. One, there should be a proper and detailed criteria for selecting judges. I have been saying this for many years now, that if you ask any Chief Justice, today one of the Chief Justices was here, as to what do they look for when they select judges, they will say that they look at competence and they look at integrity. Competence, they say, we know because these lawyers are practicing before us, or from the judgments of the judges in the high courts, if they are being considered for selection to the Supreme Court, we can evaluate competence on the basis of that. And they say integrity, well, we rely to some extent on the IB report or any other information that we may get from here and there about the integrity of the person. But the first question is, are these two enough to select judges? For example, I'll just give you 2 or 3 examples. What about judicial temperament? A person may be very competent. A person may also have integrity, but he may have no judicial temperament. Justice Kardju is a very good example of that. He had integrity, he had competence, he was certainly competent, but he had zero judicial temperament. He had no judicial temperament whatsoever. So that's certainly an aspect which has to be considered when appointing a judge. What about common sense? Now, common sense is the most important quality for a judge. A judge may be a lawyer may be highly intelligent and therefore may appear to be very competent, but he may lack common sense. What about commitment to the principles of the Constitution? Again, a judge may be highly competent. He may also be a man of integrity, but he may believe, as Professor Mohan Gopal pointed out, he may believe that, yes, the Hindu dharma or the Hindu Rashtra is what is required. So therefore, he doesn't then adhere to the principles enshrined in the Constitution. Why do you not? What about his understanding of and sensitivity towards the social reality of the country? Is that also not an important quality to be seen in a judge? There are so many important complex cases, public interest cases which come before judges, which need judges who have some understanding and some sensitivity to the social reality of the country. Now, in England, there is a Judicial Appointments Commission which has evolved a criteria which has 15 ingredients. Here we just, and how do we evaluate competence or integrity? There is not even a proper system for evaluating competence or integrity. IB report is absolutely useless. How can you rely upon an IB report for evaluating the integrity of a person and you don't even put across the material that the IB gives you to that person? Well, the IB is saying that you are a boozer or you are an alcoholic. Now, what do you have to say? If they had put this thing to that judge, of course, I don't want to say much about that particular judge, but if they had put that to that judge, he would have at least said that, look, I am not an alcoholic, I have not touched a drop of alcohol in my life. So how do you at all rely upon some intelligence report of the IB which says things without providing the evidence to back it up? Unless there is absolute concrete evidence, it's just hearsay. IB or any other organization, it's just hearsay. So you don't have a proper system of evaluating people even on the minimal criteria of integrity and competence that you have laid down. How do you evaluate competence? You say, how does the Supreme Court Collegium evaluate the competence of some High Court judges who are being recommended? On what basis? Ultimately, the decision is of the Supreme Court Collegium. They may know nothing at all. And we know that there are lots of prejudices, etc., which operate. And therefore, the Collegium, there are consulting judges. Suppose there is no consulting judge of a particular High Court. What does the Collegium do? And even if there is a consulting judge, that consulting judge may have his own prejudices, etc., his own biases and prejudices. So this is certainly not a satisfactory system for judging the most competent people to be selected for appointment of judges. And one of the reasons why this is not satisfactory is because judges of the collegium are very, very busy sitting judges. They have they have their hands overfull with their judicial work. They have hardly any time to devote to a proper evaluation of candidates. Justice Indira Banerjee pointed out that we must look at all eligible candidates, or at least those who have been recommended by even one judge. Okay. From anywhere, one judge, one sitting judge, or some president of the Bar Association, that would make a very large field of eligibility. Every year, more than 100 judges of the High Courts and the Supreme Court need to be appointed. In order to select 100 judges, you need to evaluate at least 1,000 people. And 1,000 people on a detailed and elaborate criteria, and you must have a proper system of evaluating them. This job certainly cannot be done by sitting judges or by the law minister. It can only be done by a full-time body. We have been saying for the last 20 years continuously that we need a full-time Judicial Appointments Commission, not an ex officio body, and this Judicial Appointments Commission must be completely independent of the government. Of course, it should have some retired judges, it should have some jurists or some good academics, etc. And it can also have some other public intellectuals, etc. Because even if they have no experience of the judiciary directly, meaning that even if they have, if there is a proper criteria laid down, if there is a proper search committee or a secretariat which puts together all the relevant material on all the eligible people, suppose there are 1,000, 2,000 eligible people, as Justice Indira Banerjee pointed out, every information which is relevant to those candidates must go into that database, must go into that bank, and all that must be available to that selection committee. And thereafter they can also interview them, and thereafter that selection should be made. So therefore, I have always been of the view that there has to be a full-time body for this selection. Secondly, transparency. Now, Anjali has pointed out that the Supreme Court, you see, the Supreme Court was the first institution to say, first in 1974 in Indira Gandhi versus Raj Narayan, when the issue was the disclosure of the Blue Book, which contained security instructions of the Prime Minister in her election case. Now, in that case, the Supreme Court said that the people are the masters of the country in a democracy, and the masters have every right to know everything that their public servants are doing in every detail. And after that, in case after case, SP Gupta, ADR, where the Supreme Court said that candidates in contesting elections have to disclose information about their assets and liabilities, about their criminal record, etc. In PUCL thereafter, where they struck down a law which tried to overrule it. Case after case after case after case, the Supreme Court, without even a right to information law, has said that it's axiomatic that in a democracy which is governed by the rule of law and in a republic where citizens have the right to free speech, the citizens have every right to know everything about what public authorities are doing, barring some exemptions which have been elaborately laid down in the Right to Information Act. And that is why the Supreme Court itself, in the selection of Chief Information Commissioners, said what Anjali pointed out, that you have to lay down a criteria for selection, make it public. You have to have a search committee. You have to have a list of eligible candidates, make all that public. So the whole process of selection, including the reason why you have selected certain people, should be laid down. And that's what even the collegium said once, that we will now maintain minutes of selection, we will now give reasons for selecting certain people, and we will make it public. And for a short while they did. But then they reversed their own decision. So the result is now that only some cursory information is given. I mean, sometimes detailed information is given. For example, when they recently reiterated the selection of Saurabh Kirpal and another person, they gave very elaborate reasons as to what the government's objection was, what the IB's objection was, and why they overruled that objection. But sometimes no information is given. So as a matter of general rule, all these things must be given out. Number one, the candidates, the eligible candidates who are in the zone of consideration, the minutes of the selection committee, the list of shortlisted candidates, so that, you see, the people also need to be given an opportunity, just as the government is given an opportunity to say what it wants to say about the persons who are being recommended for selection. The people of this country also need to be given an opportunity. Just as Lokar pointed out, that lawyers by and large come to know whose names have been recommended by the High Court Collegium. But only lawyers come to know. Sometimes other people don't come to know. Sometimes even the lawyers don't come to know. Sometimes when we come to know, as we did recently in the case of one particular recommendee of the High Court, we discovered things which were flabbergasting. And we submitted a detailed representation to the collegium, pointing out that this man is utterly dishonest. But unfortunately, he still came to be appointed. That also speaks volumes about the manner in which the collegium is functioning. So therefore, all these things need to be put out. The basis for the selection, the minutes of the selection committee meetings, the short list, of course, well before the selection is made. So with fair degree of transparency, we expect that the collegium will also function better. But even for the collegium to function better, they need to lay down a better, more detailed criteria and make it public as to what are they looking for when they are selecting candidates. And they need to also put out how they go about judging people on this criteria. So these are just a few things that I had to suggest. Thank you very much.
Thank you very much. And I think we've managed to unpack several facets of the principles and frameworks for appointment of judges. So while preparing for this, I was just trying to look at that. Has there ever been a successful example of infusing diversity in appointment processes, especially for judges? And there's something very interesting that I found from Canada. So this is from one of the province's Judicial Appointment Advisory Committee, which was set up in 1988. And looking at the lack of representation of women, they actually wrote to 1,200 senior female lawyers, trying to persuade them to actually apply and be a part of the whole process of selection. And a few years later, by about 1990-92, 40% of the bench actually were women. So perhaps this is the kind of thing that's needed, targeting marginalized and underrepresented communities, persuading them, following up, perhaps even facilitating the application process. Now, there would be a resolution that's going around to all of you, and I invite. Would you like to make it from here? Okay.
I just have one or two moments to make. There can be no doubt about the need to disclose and into the public domain the criteria for selection.
You have to call him again.
Except exceptions may be permissible, but there should be strong reasons in support of the exception. I disagree with Anjana over one comment which Anjana made. The income criteria is not looked at on the assumption that those who are well off will not be dishonest and those who are not well off. It was in the context of something else, but anyway, I was not aware of that. The reason for looking at the income criteria is how do you judge whether a lawyer is in practice or not, whether a lawyer is in active practice or not. And that is the reason why I was suggesting that exceptions may be permissible. But when there is an exception, you mention the rule. Like I mentioned that lawyer X does not meet the income criteria, but this lawyer does pro bono work. This lawyer works for the cause of such and such group. And this is the area where he has or she has done worked competently, and these are the reasons why I think that he or she will be a suitable judge. This is one. The second is Madam Bharadwaj. She referred to disclosure of all names in the public domain. The ones who are being selected may certainly be disclosed in the public domain, but there is a difference between selection of the information commissioner or the Lokpal and selection of a judge from amongst lawyers. If a question I would like to put to maybe Madam Gruber, would you accept an invitation to even be considered for elevation if you ran the risk of not making it and your name being put in the public domain, your name being disclosed? Britna probably would, because she's already named. She would not accept education. She's in the public domain all the time, but I just gave it by way of an example. Would I? Okay, let's put it the other way around. If I had been given an offer and there was always a possibility I may not have been selected. So many good candidates don't get selected. Would I have even agreed to be considered if I would be running the risk of my name being publicly disclosed as having been considered and then being rejected? I would lose my private practice. So therefore, that disclosure should be subject to the candidate concerned asking for or agreeing to it.
So can I suggest something?
And those who are selected, yes, there should be a disclosure. If I'm selected, any question about me, there should be an answer.
So can I just suggest one thing, that we have actually time for the Q&A. Should we get the resolutions passed and then the can of worms that Justice Banerjee has opened right now, then perhaps we can take those.
Resolution should come at the end.
Okay, so we'll take the resolution. Okay, so then we are now open for Q&As and whoever.
Also, if I may respond to what Justice Banerjee said. See, the thing is that once an appointment has been made, once a selection and appointment has been made, there is no use in the name being put. Of course, the name always comes out in the open once the selection has been made. But the whole object of putting out at least a short list of those who are being considered in the open is so that the public can also give all relevant information about those shortlisted candidates. Suppose, as we knew about as we came to know about one of the particular people who had been recommended, fortuitously we came to know because we asked one of the retired judges, like Justice Madan Lokur, in fact, who found out from one of his former colleagues in the High Court. Only then could we send that representation. It's another matter that such a strong representation was also either not considered or rejected by the collegium, and that person still came to be appointed. But the point is that at least some very relevant information bearing very strongly on his integrity could be submitted to the collegium. In America, of course, there is a system of Senate confirmation, which is a very, very tough, rigorous grilling of that candidate by any member of the Senate, etc. We are not even suggesting that. We are only saying that at least the names of the shortlisted candidates should be made public, so that at least the people can send whatever relevant information they have about that candidate, good or bad, to the selecting committee, to the selection committee, so that it will be considered. No, even those who are being considered. So if the process is that you first draw up an eligibility list, then you make a short list. At least the short list should be sent out so that if people have, of course, after taking their consent as to whether they are willing to be considered for appointment. If they are willing to be considered for appointment, then.
Discussions that happened since the morning, Justice Banerjee, were also about radically rethinking the kind of transparency that has been in the appointment process. And I think that this is one of the concerns that has been very often put forth. The problems, again, that were being discussed today were the kind that Prashant alluded to, and also the fact that, the more we are carving out a niche, a special niche for the judicial appointment process, the more, the process is becoming susceptible to either arbitrariness or nepotism, and the only way to open it up, and one of the suggestions that also has come is that of self-nomination, where, we really need to encourage more and more people to apply. And of course, there would be people who can be approached and encouraged, and very often they might even need to be facilitated in terms of applying. But all of those names to be in the public domain so that people know who is being considered for these very high public offices. And yes, it was felt, and it was also expressed in the morning, this feeling that there might be some petitions that might start, there might be some of that that might happen, which also happens with other high public offices, unfortunately. But it might, on the balance, be a small price to pay, in terms of ensuring that there is greater transparency and accountability to the process. So that's where
there is a practical problem which we have often faced. That is, we request competent lawyers, to agree, and they refuse straight away. This is a problem which, particularly, in high courts like Calcutta, Delhi, Madras,
robust enough to become a judge, should also be robust enough to face. See, this.
Today Mr. Somni was here, and he talked about his experience as well. And I think there have been cases where they have said that we are actually wearing it as a badge of honor, that the name was not accepted by the government, and therefore the judgeship did not happen. But yes.
Not accepted by the government. it's taken in one way, not accepted by the collegium, it's taken in another way. And every information has to be a very detailed one.
So can I now invite Professor Mohan Gopal and Brinda Grover to also join us at the panel, because we are now opening it up for questions. And can I request the panelists that let's take 2-3 questions, and then perhaps each of you can answer this vexed issue, but also others that perhaps the audience would also like to highlight.
Say something on in response to this, on this point. Okay. See, I just wanted to give you a practical example on this. I read in the newspapers recently a list of names recommended recently by the Collegium for High Court judges. I've been a member of several national regulatory bodies. When I was a member of one of these bodies, there was a lawyer who was a very successful lawyer, very high incomes, complies with all these criteria that you said, who played a very dodgy role in undermining that regulatory commission in its work, deliberately and deliberately and knowingly. I don't think this is brought to the attention of any of the. I just came to know. In fact, I was shocked to see this name. So I'm still thinking: is it too late now, or should I write to? Who should I write to? But the point is, it's only because that name became public that it is a very highly reputed lawyer, very successful lawyer. Yes, his name will be. I hope his practice will be affected if he is not accepted by the High Court.
It won't be affected.
No, but unfortunately not. But what I'm saying is rightly it should be affected. If the reason is good, the objection is good, I feel they should make the objection also public. So that if it's a worthless objection, people will say, why did this worthless objection get made by this worthless man? No, what I'm saying is, but if it is truly worthless or malafide motivated, then the public will judge that. But if it's a substantive concern, then people should know. So I feel, while you're right, you're absolutely right, that we may lose some good people. I think your point is well taken, that some good people with nothing to hide may still feel that I don't want mud thrown at me, and I'd rather not be in the process. But that's, we have to weigh that price against the advantage of ensuring that the wrong people do not get appointed to this judicial position.
The opposite principle of criminal law.
Yeah.
That one.
Yes. No, but it's just to make it very.
Even the good people must understand, if I live in a democracy,
The stakes are
then
high.
and I want public office in a democracy, then I cannot seek public office. So it's their choice. I'll have to keep everything. But if you want public office, as Prashant very nicely said, everything about everyone in public office is open to scrutiny. If not, stay away from public office. But you can't have your cake and eat it too.
Hello. Yes. 1 second. Okay. We will be taking limited amount of questions. Okay.
So we can maybe
Take all questions together. Okay.
I think I would agree with Professor Mohan Gopal for this reason. I think the need to know is at a very high level, because it's a need to know which ensures transparency, and I think that impinges on the integrity of the person, it impinges on the suitability of the person, it impinges on every criterial aspect of that appointment. And I think therefore that should really trump it. I do understand that there is a certain amount of a searchlight cast on a prospective candidate for judicial office. And indeed, if somebody says, but I don't want that searchlight, then I think one should allow them to step away from the searchlight. But if the searchlight is cast for good reasons, and those reasons pertain to the requirement of bringing the best into high office. That's, I think, the way we may make prospective aspirants look at it.
You weigh the stakes, actually.
You weigh the stakes.
So we'll now take 3-4 questions from the audience. Harsh.
Thank you. We learned a lot. I have two difficult questions, and slightly unclear question. In a judge, perhaps most of all, I'm looking for moral courage. That goes beyond integrity. In times when democracy seems more and more threatened, where we're seeing the executive take decisions that to an ordinary citizen seem more and more in contradiction to the Constitution and its morality. We're looking for judges who have moral courage to stand up. I'm not seeing anything in this process that will attract and help us identify judges of moral courage. That was one quick question. And the second is tangential, but I've seen some of the finest judgments in these recent troubled times from so-called lower courts. And I think there doesn't seem to be a system to protect them. And shouldn't we be spending a lot of time thinking about what we can do for the so-called, I don't know a better word than the lower judiciary, district courts and their protection when they display moral courage.
There's somebody in this room.
Thank you, sir, for giving this opportunity. Ma'am, are you selecting the best lawyers or the best amongst the worst? Because our bars, the way the elections are held in the bar, where the legs and the pegs count a lot, and you know how the elections are held. Number two, why the Supreme Court, what are the compelling reasons that the Supreme Court does not invoke the contempt of court in cases where the law minister is sitting on the file once you have sent the file back? And third is, as the Supreme Court in the second judge's case, they gave the power of appointment to themselves. Why can't the Supreme Court, why does not the Supreme Court itself have come out with a judgment that, look, there should be no post-retirement rehabilitation of judges of the Supreme Court and the High Court, including the IAS and IPS officers, having some kind of a cooling period, except in tribunals where it is laid down under the law. These are my questions to Prashant Bhushan sir and to Madam.
When the government sits on reiteration, unanimous reiteration of appointments. The second post-retirement jobs. These are the two.
How can I answer this question? How can I answer this question? What exactly constitutes contempt? You have criminal contempt and you have civil contempt. When there is a violation of an order of the Supreme Court, a judicial order, then that constitutes civil contempt. When there is an action which lowers the dignity and majesty of any court, then that constitutes criminal contempt. Now, there may be two opinions as to whether this comes within the purview of civil contempt, whether a recommendation made is a judicial order or not. The other way of looking at it may be that the sending sitting on the name may constitute a mandamus may later be issued having regard to the judges, the 3 judges cases which make it mandatory for the government. But whether contempt would lie or not is maybe doubtful. Yes, if a mandamus is issued, if some kind of order is issued and that is contrary.
They have to first issue a mandamus and then proceed with contempt. I mean, that's the way technically
While it's not being done, they're considering the matter, they're hearing the matter, there's a bench deciding. Now, sitting here, it is very difficult for me. Maybe an adjournment has been sought, maybe directions for some affidavits may have been given. It's very difficult for me to answer that question sitting here about why a particular bench is not taking this decision. Post-retirement, there is no constitutional bar. Now it is left to it is like the accuser, it's the conscience of the judge.
saying should there be a bar other than for tribunals, etc. Shouldn't there be a bar for things like governorship, Raj Sabha membership?
Prashant is adding his own question to the original question.
I'll give a very jocular answer to it. If I say there should be a cooling off period, then you may say grapes are sour, you've not been given an offer, so you're giving this answer. And if I say there should be no cooling off period, then you may say you're hankering for an appointment and therefore you're giving this answer. So I refrain from making any comment.
Would anyone on the panel want to take Harsha's question about the issue of how do you look at and assess moral courage and how do you protect lower judiciary, which often stands up to executive excesses?
Who is in control of the judiciary? It's not the government. It's the High Court. Any decision with regard to the judiciary has to be taken by the High Court. And the role of the High Court there is like a parent, where you discipline the errant officer and you protect the courageous officer. Any decision has to be taken by the full court. It's not taken by any one judge.
Sometimes what is pointing out is
It happens.
that the opposite
The
happens.
aberrations do happen, but it should not happen. You should protect.
His question was different. He's saying,
Ah.
why shouldn't moral courage be part of the selection criteria? This is what.
It should be. It has to be. That is the criteria. Courage, integrity, temperament. These should be the criteria for selection. If that has not been done.
The point is, the proof of the pudding is in its eating. So how do you know whether that person has moral courage or not? Unless it is put to test. That's the
Yes, exactly.
So having it today, saying, that I am very honest and all that, really amounts to nothing. It's when I am put to test, when I am being bribed, attempted to be bribed and I refuse it. Only then I can say that I am truly honest. But I don't think.
Well, sometimes
Offers of bribe come to all judges.
No, it doesn't. I'm just talking about it.
Very, very sadly, I've never got such an offer in my life.
Please wait. Please wait.
I wish some of the high courts would show some of the courage that the district courts show. Especially when it comes to matters around for bail. And High Court judges, I'm told High Court judges saying that if I grant the bail in this DMA case, I'm scared of being, posted to Pakistan or to Kashmir. So I would very much, recommend that those that kind of to the High Courts. Moral courage, I think it's a great point, but one needs to have the occasion to spot it. I mean, if there is a lawyer who has, let's say, taken up challenging public interest matter, fought against George, fought against the government, fought against people in power, it's an exhibition of moral courage, and that should be highlighted. Very often, to be quite frank, the occasion for the individual to show moral courage rises after assumption of office. That's when we can get surprises both ways.
So, we have a question here.
Hi.
Please wait. We'll get the mic across to you, otherwise it's not getting captured.
While we...
Can you...
But judge of the High Court does not have the moral courage. Is he fit to be a judge? Or for that matter, a judge of the Supreme Court?
While I completely agree with Mr. Prashant Bhushan that appointment of judges, that to hundreds and thousands in 1 year, is a work which is fit for a separate body rather than the Chief Justice and the 5 judges. But till that time that day comes, can a compromise like that Chief Justice and the other 3 or 5 judges should only sit on very select constitution law matters and not sit on every day so that they can dedicate a lot of their time? Because I have heard one video by Apple CEO, Steve Jobs, and he said the most important job that I do as a CEO is select the best man, and the rest of the thing gets done automatically. So in that spirit, if the Chief Justice only dedicates most of his time in selecting the best people, he might not have to administer everything himself. And the second one is, we in the previous session, we have talked about that High Court works as a feeder for the Supreme Court. But that is not true for the High Courts, because High Courts somehow has devised their own mechanism that so can the lower district judges, instead of supplying only 1/3 of the judges, can they supply 2/3 so that the High Court also have less selection to do, and automatically best of the best candidates come to the High Court and a lot of job gets done automatically? Thank you.
Shall we take a last question from here and then from the panel, whoever would like to?
I was just saying that Your Lordship has answered that question of post-retirement answer from grace. But in certain cases, the rules are changed where payments are made of commissions and other things. So, a former minister of the law minister had said in a speech that post-retirement appointments are influenced by the judgments. In a responsible position, he had said. So the judgments which are passed and then the appointments are given. On that point, if Your Lordship kindly give some reflection, and could there be something of that sort in this resolution of that sort in this resolution? That was I was saying.
And just the last question there, and then we'll close the floor for questions, and the panel will have an opportunity.
I can give you an example and say, let us say, the National Company Law Appellate Tribunal. There are so many pending cases, you can't afford to keep the position of chairperson vacant. A very competent judge gets appointed immediately. I don't think there is anything really wrong with that. And what the law minister is saying outside, we only read newspaper reports. I had no occasion to talk to the law minister. I didn't hear him say anything. So it is all newspaper reports. And so far as reporting is concerned, without any disrespect to anyone, there can also be a little bit of it is a person's understanding. Sometimes, it may become like the Chinese whisper where Mr. Bhushan tells me something, I say something to Anjana tells me something. And by the time it goes to Professor Gopal, it takes a U-turn. So I have not heard him, but he should not be saying, if he Certainly, any appointment should not depend on any specific judgment that we have to do. But by judgments, he may have meant the quality of the judgment or the area in which, that judge has decided cases. Now, if he had been taking up IBC cases by the Supreme Court or taking up corporate cases by the High Court, candidate to be.
Yes.
Just a last question from the floor.
सबसे पहले मैं आप सबका शुक्रिया करना चाहता हूँ और मैं एक कोर्ट एम्प्लॉई हूँ पंजाब का, हमारी तरफ किसी का ध्यान नहीं रहता। हमारे कई एम्प्लॉय सुसाइड कर चुके हैं और जस्ट बिकॉज रिफॉर्म्स की बात करें तो मैं पिछले 10 सालों से रिफॉर्म कर रहा हूँ, रिफॉर्म की कोशिश कर रहा हूँ अपने एम्प्लॉयज के लिए, सर जानते हैं। अपॉइंटमेंट की सर मैम रविशंकर झा जी का हमारे चीफ जस्टिस है पंजाब हरियाणा हाईकोर्ट के 229 की पावर में अपने क्लरिकल स्टाफ की रिश्तेदारी में भर्ती कर रहे हैं। लोअर कोर्ट की क्लास 4 की एम्प्लॉयज में जो भर्तियां हो रही हैं वो उनमें भी बहुत सारी करप्शन चल रही है। तो यही पूछना था बस, ये इसके रिफॉर्म्स के बारे में क्या रहेगा, इसीलिए वो सुसाइड कमिट कर रहे हैं। नीचे बहुत ज्यादा टॉर्चर हो रहा है एम्प्लॉयज के साथ, कोर्ट एम्प्लॉयज के साथ।
There's just one more question. Sorry.
Hello, good evening. My name is Saurdas. I'm a journalist and I broke the Victoria Gauri story. I just have two questions to ask because we have two former judges sitting here, one of the Supreme Court and one of the Delhi High Court. So, Patna High Court, sorry. Yeah, so my question is, if you have followed the case, how much did you agree with the Supreme Court not staying when it had the time to stay the oath-taking ceremony of a judge where there were clear evidence that she may be unfit to hold the office, number one. And number two, if the case was given to you, what would you have done? What different or what similar you would have done?
What I would have done would depend on the materials which were placed on me. What was there in the pleadings? What were the materials produced in support? What was the veracity of what was said and what was the law in that regard? Whether the court can issue a mandamus or not in a case like this. Since I had no occasion to go through the papers, I'm not really in a position to make a comment as to what I would have done.
As for me, I'm practicing in the Supreme Court. I would rather not say anything against the judges who are the case. But you get the point.
So I invite the panel if any of you would like to make any comments in 2 minutes and then we'll go to the resolutions.
आपने क्वेश्चन नहीं पूछा, आपने अपनी प्रॉब्लम बताई। अब प्रॉब्लम तो हम लोग कोई पंजाब हाई कोर्ट में नहीं है जो आपको मदद कर सकेगा। कोई पंजाब से रहता तो कोई बात हो सकती और हम लोग की कोई पहुंच नहीं है। आप मैडम को आप डिटेल्स दे दे, she can write to the Supreme Court.
आपने तो डिटेल्स नहीं दिया, किसका अपॉइंटमेंट नहीं हुआ। वो सुसाइड का रीजन क्या है?
एक्चुअली मैंने ये देखा था जो ये बता रहे हैं, क्योंकि I had the occasion to send a very detailed representation on behalf of CJAR based on documentary information that they had supplied. After which the then Chief Justice of Punjab and Haryana appointed a committee headed by Justice Suryakant to examine all these grievances and complaints of the subordinate staff of the district judges. There is considerable material to show that the subordinate staff of the district judiciary in Punjab and Haryana is being rampantly misused by the district judge.
Unfortunately, similar complaints.
There are many in UP also. Now, on that representation, that committee gave a detailed report saying that a grievance redressal mechanism should be established, that these rules should be changed, etc., etc. But even after that report, which came about 5 years ago, 6 years ago, when Justice Surikant was still in the High Court, even thereafter, those recommendations have not been implemented. There is a case pending in the High Court regarding that, which the High Court, because actually that just goes to show, just as happened in the Ghaziabad Provident Fund scam, that very often, or at least quite often, the High Court judges are misusing their administrative control over the district judiciary to get some favors from them and thereafter overlook all the abuses that they do over their own subordinate staff. This is what unfortunately has been happening. It's a very, very serious problem. He is right. Many people have committed suicide.
So can you do one thing?
No, I can give you all that material. This is pending in the High Court. Problem that is happening is High Court is not dealing with all that because there is this kind of cozy relationship between the High Court. Fortunately, at that point of time, the Chief Justice was from Bombay. He came as the Chief Justice, he appointed a committee, Surikant gave a very good report, but unfortunately after that nothing was done. Just two quick on Saurabh's questions. Not Saurabh, the other person, sorry. So two good suggestions came from him. One was that I feel both of them are good suggestions. That in the absence of a full-time body to select judges, can't the collegium judges spend a little less time in deciding cases and more time in selecting judges? That's certainly something which can be considered. The second suggestion that you made was that instead of 1/3 judges to the High Court going from the lower judiciary, why doesn't a higher percentage go from the lower judiciary? I think that's also a good suggestion. Because it's not that there is any dearth of good judges coming up from the lower judiciary. The impression, that's my view of the matter, the impression that has been created that the only good judges you can get is from among the lawyers of the High Court and the district judges do not make good judges, I don't think this is the correct view. And I think a larger proportion can come up by promotion.
Can I just disagree with Prashant?
Yeah, sure.
Both suggestions. One, I think judges, as was said earlier also, their prime task is of judging and adjudication. And I don't think we want the senior-most judges to actually not be doing that primary task and instead be devoting more time to her. I think instead one should be pushing for the secretariat that has now been thought of for quite some time. It's not a new suggestion being made today. Many have written about it, and we need to push that idea so that they have the necessary support. It's not as though the Chief Justice or the Collegium can actually start going around asking people themselves. They will still need a body that is going to feed them the relevant information. Secondly, insofar as there is no, as somebody who's practiced and continues to practice both in the district courts and elsewhere, it's not whether they are, they only, all the good judges are coming from the bar and these are not. But many of the criteria that we are today talking about are not criteria by which you get enrolled in the district judiciary. There's a district judiciary exam. Please look at the results that come out of district judiciary exams. They are finding it hard actually to fill on simple criteria of knowledge of law. There is no other additional criteria there. And of course integrity, etc. would be. You're not going to dishonest people, whatever be your means of evaluating that. Therefore, to say they should be the bulk of the judiciary would then definitely impact what goes into the both in the High Courts and the Supreme Court, so we should have some caution there. I just want to add 2 quick points. I think there are 2 words that need unpacking. One is competence and one is integrity. And for too long, competence and integrity have had a very limited interpretation, particularly while selecting judges. In and of itself, they sound that they can occupy a universe, but competence has been interpreted as good practice, knowledge of the law. And integrity has been largely interpreted as not corrupt. Those are certainly we want, and we are asking for much more. And for instance, I really think it is very high time that any person who's been brought in as a judge of the Supreme Court, by which you definitely have a huge body of work of that person available, of that lawyer, of that judge, please look at judgments written on gender. They are available in the public domain. It has never been a criteria while appointing judges to the Supreme Court of India. So half the population is immediately impacted. 80% population is impacted because you don't see how do they look at the poor. Why are these not part of competence? Competence is not knowledge of the law. Knowledge of the law is actually the easy part of law. It is these biases which are causing the fissures and the discomfort and the alienation. And the courts, the collegium has to bring these factors in.
Thank you. Would Mr. Panchu like to make any concluding remarks? Anjali, any concluding remarks?
I think the issue of criteria has been discussed, and what Harsh was also pointing out in terms of moral courage. We do need to understand what are the criteria. They need to be very nicely fleshed out, and they have to be put out in the public domain. And there has to be also openness in terms of public consultation, because for too long, I think, things have been kept very firmly in a domain which is not public, where public feedback is not invited. And I think that, especially in terms of criteria, whether they are the ones that Prashant talked about, or Brinda, or Justice A.P. Shah also in the morning, I think we need to evolve a set of criteria. Again, the Supreme Court has, in several judgments, ADR, PUCL, etc., required certain disclosures which are to be made by people who are seeking public office. And in 1997 also, in a full court resolution, assets and liabilities of judges, it was decided that they will at least be disclosed. I think in the time of right to information, at a time when somebody also raised questions about judicial corruption, I think it's very important that at a time when people are being considered for the position of a judge, and even subsequently, people must have a right to know about all of these things, whether it is educational qualifications, criminal backgrounds, or it is assets and liabilities. And it is indeed alarming that today, although it had become practice that judges of at least the higher judiciary were putting out their information about assets and liabilities in the public domain, today not a single judge of the Supreme Court has their assets and liabilities disclosed on the website. So, and of course, post-retirement jobs, at the time when there is an application made, if there is a self-nomination, it should also be part of that process where the judiciary needs to think about it and perhaps have some sort of an understanding that a cooling off period has to be introduced unless it's for a specific tribunal.
It's not on the website, maybe, but subject to correction, because I was appointed 21 years ago as a judge of the High Court. In the form which I filled up, I had to mention at least my immovable assets, club memberships and other things which I had. Apart from that, in Calcutta High Court, I had to disclose my assets. And again in the Supreme Court, so it is there in the records of the Supreme Court. Anyone, it is not put up there because I suppose because
conflicts with the right to privacy. But anyone can ask for it.
Just one very quick comment. I think in the Victoria Gowrie case, the judgment has reiterated, to use a word we used a lot today, the view from the third judge's case onwards, that the most important part of judicial selection, namely assessing fitness and suitability, is not subject to judicial review, although it is an administrative action and should be subject to judicial review of administrative action. I think perhaps a couple of words can be added to this otherwise excellent resolution to also indicate that all aspects of selection and appointment, being administrative in nature, should be subject to judicial review. So just reference, because that's, I think, extremely important. And I think I just want to say in regard to, I share the concerns expressed on the proposal that judges should be diverted, senior-most judges should be diverted to hiring. Because frankly, most of them, I worked at the Judicial Academy, there we actually went into this at length. We organized conferences and so on. And we found that actually as lawyers and later as lawyers before they become judges, these individuals have had absolutely no experience in personnel management or recruitment or selection at all. They're just doing their legal work. And once they come to the bench with no knowledge or expertise of human resource management, which is true of me and true of all of us here. We are not experts. We underestimate the professionalism of human resource management. So one idea that emerged from several rounds of conferences at the National Judicial Academy, it's never been acted upon, always accepted but never acted upon, like the collegium recommendations, is that the Supreme Court and High Court should develop what I can crudely call a human resources wing or department, where they will have actual expertise on human resource development, people who are skilled. Like Steve Jobs, he's a manager. These guys are not managers, they're lawyers, right? So managers can devote themselves effectively to selecting people. They can't. So we must establish...
In Jharkhand, I think they've started this court management.
No, court management is a separate thing. Yes, that we started from here, National Court Management Systems. But as part of that, they should, what I think Prashant has been proposing is a very good idea of, and you don't need, even within the judiciary, you can have an independent unit in charge of human resource management, selection, appointment, looking at best practice. The interesting thing is, what we're discussing here is not sort of, we are reinventing the wheel, because there's enormous experience worldwide. And we exposed judges to this in the National Judicial Academy, enormous experience on all. There is no perfect way, but on how to select a judge. It's a very tough choice. And on moral courage, as rightly said, we cannot predict it, but we can recognize and reward it and provide an incentive and a protective shield, which is what Whistleblowers Act actually does. It provides a legal protection for moral courage to speak out against the powerful. So we can provide that kind of protection within the judiciary. We can provide recognition. I'm happy to say that the only portrait in the National Judicial Academy that is not ex officio is that of the district judge who wrote the judgment on Union Carbide. Yeah, I got a painting. There was no photograph available. I got somebody to paint his picture, and we put it on the National Judicial Academy. So the only portrait of a judge in the National Judicial Academy that's not ex officio is that of a district court judge. So we do recognize, we do appreciate, but we need to provide protection. I think that was your main point, that they should need to be protected. So something like a whistleblower type regulation must be put in place inside the judiciary itself, on the administrative side. So I think these are all things that we can do, but let us not underestimate the complexity of selection and appointment of judges. It's very complex. I agree that we need not only capacity, but expertise in human resource management to be part of that solution. Thank you so much.
Thank you. I now invite Anjali to read out the resolutions, and that's something we're proposing that we pass them collectively from this seminar today.
Yeah, it's there with everybody. We just want to make sure that this is something that is agreeable. Everyone is agreeable with this. The members of CJAR and participants of the seminar on judicial appointments and reforms organized by CJAR today hereby declare that. And if anyone has any objections, please let us know. We strongly oppose the government's attempts at interfering and stalling the process of judicial appointments. The protection of people's rights is closely linked to the functioning of a fair, independent, and effective judicial system. In the constitutional scheme, the Indian judiciary occupies a pivotal position as the guardian of the fundamental rights and liberties of individuals and against executive excesses. Safeguarding the autonomy of the judiciary, which includes the process of appointments from government control and interference, is paramount. Is everyone okay with this being passed? If we could have a show. The second is, we believe, to ensure a robust process of judicial appointments based on a consideration of a wide set of suitable candidates from diverse backgrounds, a full-time secretariat or committee needs to be established, which would provide the necessary support to the collegium in terms of searching for eligible candidates, assisting in analyzing the judicial performance where relevant, and providing secretarial support. In the long term, a proper and robust consideration of all eligible candidates and evaluating them on a broad-based criteria and detailed rational criteria requires a full-time judicial appointments commission and not an ex officio body. However, such a commission must be completely independent of the government to maintain the independence of the judiciary. Are there any suggestions to this, or
One suggestion about that in the first paragraph.
safeguarding the independence of the judiciary, you said, instead of
autonomy. Rather than autonomy.
instead of
Publicly declared.
Publicly declared judicial criteria. Publicly declared.
Okay, so we can make it a publicly declared criteria. Declared. Okay, so in keeping.
And publicly, just before.
Yes.
In the first paragraph, this word autonomy.
Yes, we've done that. So are we okay with the second point? Yes.
Of the collegium.
Okay.
Annual report of the commission, actually, the search committee or the commission.
So you mean the annual report of the search committee or the commission?
No, he
Or-
was talking about the annual report of the commission.
Collegium. But that's available on for whatever it's worth. It's available.
Yeah, of the committee.
And if the committee is formed. Okay, so we can add that point. Then the third is,
If you have a report, then the collegial resolutions should also be more detailed. It should not simply be so is
appointed.
Recommended and found best or found good.
There should be reasons for the recommendation, you mean?
Reasons should be made public, as
Right.
it was for just over a year between 17 and 18.
So that finds place in the third point. The process of judicial appointments must adhere to fundamental principles of transparency and accountability, including ensuring public disclosure of decisions, comprehensive documentation of the deliberations, and a mechanism for receiving feedback about proposed amendments.
Decisions along with reasons.
Decisions along with reasons. And the suggestion that was made by Professor Mohan Gopal was all aspects of judicial selection should be open to judicial review.
Yes.
So if
this part of and mechanism for receiving feedback is actually, they're two separate things. That and is not helping that sentence at all. These are, you're saying one is about the transparency in what
consideration.
what transpires within collegium. The other is a mechanism for receiving.
so we can separate those two and that. Okay. So are we okay with the third point? Thank you.
So Thank you for that. I'd like to invite Prashant to give the vote of thanks on behalf of CJAR for.
You can do it.
So, thank you all for coming to the seminar. Thank you to LiveLaw for live streaming it, and thank you for all the media for covering it. And a special note of thanks to all our panelists who came from all over, spending their valuable time on this seminar, on this very, very important discussion and deliberation. I think it's been a very fruitful, very rich, and very useful seminar and discussion, and I hope and I think that this will certainly come to influence the process of judicial selections in the time to come. Thank you very much.
Shall we give a round of applause to Mr. Prashant Bhushan, Ms. Anjali, Bharadwaj, and all the team members who did a great job today. Thank you.
Especially I forgot to thank all the young people, especially Cheryl, Ria, so many people, Anjali, Amrita, and many other people from my office, as well as the Campaign for Judicial Accountability, who put this seminar together. Thank you very much.
And for the session 1, we had 7,000 people watching.